it's late here this morning. I am Dan Utso, the Managing Director of the Canada-U.S. Law Institute. On behalf of the Institute, our two founding institutions, the University of Western Ontario Faculty of Law and Case Western Reserve University School of Law, I again welcome you to our 27th annual conference. I extend a warm welcome to our two national directors, our Canadian Director, Professor Kai Carmody, as well as members of the faculty, staff, and students from the University of Western Ontario, as well as our U.S. Director, John Kretzinger, and our colleagues of the administration, faculty, and staff that are joining us here at our host institution. I further extend our heartfelt welcome to the members of our Executive Committee and Advisory Board that are joining us this weekend. This has been a period not only they're providing their talents and leadership to this conference, but there have been a number of side meetings, including one pretty early this morning as we begin planning for the next year. So thank you for your leadership to our Institute. And I thank in advance all of our speakers and panelists for contributing their extraordinary talents to these conference proceedings. An event like this does not happen without the support of a number of institutions. I encourage you in your materials to see we have a list of all the sponsors, not only of the speakers, but also our members that are listed there. But I'd cite two in particular, Cliffs Natural Resources, who has provided support, who is not listed on the materials, but we thank Cliffs and Jim Graham for his support, as well as the Consulate General of Canada in Detroit and the team. I had the opportunity to meet with Robert Noble last night, as well as George Casteris and a number of our other colleagues that will be here, and we offer their support. We started last night with not only marking the beginning of this conference, but the new era of our Institute, and I again offer our heartfelt thanks to the new co-chairs of the Canada-U.S. Law Institute, Governor Jim Blanchard and Minister James Peterson. Thank you again in setting the perfect tone for the weekend. Now, as we discussed last night, and I do not want to belabor the issue that this is a weekend of mixed emotions. This is our first conference in 27 years without having in a physical presence Henry King. Henry designed this conference 27 years ago, as I stated. This was his baby for a number of his years of his life, and his children have just contacted us, including his son yesterday, and just said, remember, this is Dad's baby. And with that, Henry had a magic recipe for this conference, and it included three ingredients. The first was that this conference is always forward-looking. This is not the place where you come to hear about what's happening in the Canada-U.S. relationship. To borrow Larry Herman's phrase from last night, this is where you come to hear about the next big idea in that in the world's most important bilateral relationship. And this topic, regulatory harmonization, we began discussing this last April at the annual conference. In August, the North American leaders in Guadalajara identified this as the issue that for focus in the bilateral relationship. And as we've seen, as recently as this morning, some information came out where individuals are soliciting input, the respective governments, on regulatory harmonization. The second key ingredient is that this is a multidisciplinary entity. Of course, as was indicated by Minister Peterson last night, as you look out into the audience, this is the who's who of the legal professionals and scholars in the Canada-U.S. relationship. But in addition, we have scholars from many other disciplines, including economics, as we'll hear this morning, energy, transportation, who will be joining us. We have industry leaders represented by the number of companies that are supporting this event, as well as government officials from both the federal, state, provincial, and local levels. This truly does present a comprehensive picture of this issue, regulatory convergence, as well as the broader Canada-U.S. relationship. And Henry's third magic ingredient, which is what I've referred to over the years as the summer camp feel of this conference. Many of you have been here for a number of years. I think Michael Robinson right now holds the record at 24 years running. So congratulations to Michael. But the summer camp feel means that not only do we have the substantive component of these proceedings, but there is an active Q&A during these events. There's also the breaks, the Research in Motion BlackBerry breaks, where many of you will be, that are just as important as the substantive sessions. And of course, the meals, receptions, and always the celebratory and camaraderie that's developed in the after hours as well. And we encourage that, and that's part of building the professional and personal relationships that we do here at the Institute. Now, I'm a good Eastern European boy. I learned a long time ago with my grandmother's chicken paprikash recipe that you don't tinker with something that's been a success for a number of generations. So we keep the spirit alive of this conference, and we hold true to those three principles But we've made 3 enhancements this year. The first is, as you've seen, that this conference is rededicated as the Henry T. King Conference on Canada-U.S. Relations. As I stated last night, that's not really a change. We all call it this Henry's Conference anyway. But that does mark his legacy, and then his fingerprints rest on this. Secondly, we will conclude these proceedings on Saturday with an immediate press release identifying the topics that were discussed today. In many ways, over the years, the terrific material that's presented in these materials is provided in our Canada-U.S. Law Journal. You can see that everything is on the record. Our students on the Canada-U.S. Law Journal staff are here recording. But that still takes about 8 months to publish. In some cases longer, as we saw this year because of the volume of speakers that we had. But we want to ensure that on our final day's proceedings, that we can summarize what we've just heard and the path forward. And that will be done at our final session, and that'll be facilitated by Chris Sands, a senior fellow at the Hudson Institute, so that we can really describe in short order as to what's been happening here over the past 2.5 days. And finally, this event is really the beginning as opposed to the end point of these discussions. We have brought through this conference, we are launching a regulatory convergence initiative. This will involve a number of players. I think, as I mentioned during our advisory board, that we had over 250 emails over the last week from companies throughout Canada, the United States, legal professionals, scholars saying, I can't come to Cleveland. Perhaps they knew it was scheduled to snow. But I can't come to Cleveland, but we want to be involved in this initiative. How can we be involved immediately in the wake? And we will be working with those actors and folks like Canadian manufacturers and exporters who we were just with last week have some ideas in terms of carrying the ball forward. So this is the beginning of a larger initiative that our Institute will be pursuing over the next 18 months. So with that, I should make a programming note. You all did receive, a bag, a Canada-U.S. Law Institute bag. This is the must-have apparel item of the year. And this is the folder with the agenda and bios that you've all received, as well as some information on Connect to Canada. For those of you that are unfamiliar with Connect to Canada, it is, please log on. It's an entity, an initiative operated out of the Canadian Embassy in Washington, D.C. that will give you up-to-the-date information as to what's happening, news, events, and all of those types of things. It's a way to keep involved in the Canada-U.S. relationship that's unparalleled. You'll see, of course, our last issue of the Canada-United States Law Journal. It's a thick material. You may remember we had 42 speakers last year in breakouts, and our students did an excellent job. And my favorite, big favorite, but many of you may wonder what this is. Our great friends at Sandler and Travis in Detroit provided the flip drives for this event. It looks immediately like a business card, but if you just flip it open, it's the jump stick that you can stick into your computer. It took me about 3 months to figure out what this was on my desk. But it's an excellent, and our students have done a terrific job. All of the background materials for these sessions may be found on the jump stick, so they're there, and we'll also post those to the website as well. For those of you that are utilizing this event for CLE materials, there are 11.5 credit hours available. You do need the hard copy. Just God forbid if the Supreme Court of Ohio comes and audits, you do need a hard copy of the materials, so please make sure that you grab that outside. So without further ado, I'll now turn it over to Professor Bill Leatherberry. He will introduce our panel for today, followed by every session will be followed by about 15 minutes of Q&A. Thank you.
Thank you, Dan. On behalf of my faculty colleagues and the others in the law school community, I welcome you to the Case Law School for this conference. I have the privilege of introducing the panel for the economic impact of Canada-U.S. regulatory convergence from the Canada-U.S. Auto Pact to the North American Free Trade Agreement and beyond. One of the things I remember about Henry is that the fourth principle, which Dan didn't mention, is that the conference should run on schedule. So one of my jobs is to try to keep us on schedule. I won't take too much time, but I do want to introduce our two speakers. Mira Fickling is a research analyst from the Peterson Institute for International Economics in Washington. She's on my right here. She's been a research analyst since 2008. Her areas of research include climate change and trade issues, particularly in North America. She's co-authoring a book on NAFTA and climate change policy to be published in 2010. On my left is Professor Maureen Irish of the Faculty of Law of the University of Windsor, Ontario. She teaches international economic law, international business transactions, Canada-U.S. legal issues, and private international law what we would call, I guess, conflicts of law. She is the author of Customs Valuation in Canada and a co-editor of the Auto Pact, Investment, Labor, and the WTO, and some other publications. She has served as on the dispute settlement panels under the Canada-U.S. Free Trade Agreement and the North American Free Trade Agreement. Without further ado, I'll introduce Mira Fickling, who will be our first speaker. I think we'll hold the questions until the end. We will reserve time at the end of this program for questions. Mira.
My presentation is on North American climate change legislation, and I was really pleased last night to hear Governor James Peterson say that climate change is going to be the biggest issue between the U.S. and Canada moving forward. And from the discussion last night, it seems clear that it is in fact a huge issue, and it's going to get bigger as we move forward. First, to start with a broad question, will there be an integrated North American climate change regime? And because of different energy sources within the three countries and different emission sources, there's probably not going to be one-size-fits-all climate regime. Countries are not going to cede sovereignty over their climate change programs. But that doesn't mean that the three countries can't work together to resolve frictions, and there will probably be allowance and offset trading and just cooperation more generally. In February 2009, President Obama and Prime Minister Harper met and launched the U.S.-Canada Clean Energy Dialogue. And in August 2009 in Guadalajara at the North American Leadership Summit, the three countries agreed to develop a trilateral working plan. So the trend seems to be towards national legislation but regional cooperation on this issue. So first, I'm going to start by giving sort of the state of play of U.S. legislation, and then I'm going to point out sort of points of friction and implications for North American trade and integration of these initiatives, and then I'm going to give some recommendations that Jeffrey Schott at the Peterson Institute and I have come up with for sort of resolving some of these frictions between the three countries. First, the state of U.S. legislation. There's the Waxman-Markey bill that's sort of a joint cap-and-trade plus renewable energy and energy efficiency bill. It not only has a cap-and-trade program, but also many standards and incentives for renewable energy and energy efficiency. And that has passed the House of Representatives, and it came to the Senate. The Kerry-Boxer bill is broadly modeled after the Waxman-Markey bill. It has a lot of similarities. And that passed out of committee, but was then declared dead on the floor in terms of passing the full Senate, as cap and trade, the term cap and trade sort of became politically toxic. Another bill that was introduced at about the same time is the Cantwell-Collins Clear Act, which instead of being, the Waxman-Markey bill is 1,400 pages, it's very complex, there's a lot of allocations of allowances to different entities, a lot of subsidies, standards for different entities. By contrast, the Clear Act it's very bare bones. It sets a cap and allowances are auctioned, but allowance trading is very limited, and most of the revenues from the auctions are then returned to the consumers. And that is probably not likely to pass the full Senate either, but it has contributed a few ideas that are supposedly going to be used by the Kerry-Graham-Lieberman bill. And the KGL bill is forthcoming, but there are some details that have been released to the media. There's going to be a cap. It's going to be, by contrast to the Waxman-Markey bill, where there's an economy-wide cap. This cap is going to be limited to utilities starting in 2012, presumably. There's going to be a separate tax on motor fuels. And then there's going to be a manufacturing cap that's going to start a few years into the future. Like the Waxman-Markey bill, it's going to have a renewable electricity standard and an energy efficiency standard, but they haven't released details as to how stringent those are going to be. It's going to have stringent carbon market regulation like the Cantwell-Collins bill, and it's going to have dividends to consumers of 60% or more of the allowances or allowance revenues. The other viable bill in the Senate is Binghamton's American Clean Energy Leadership Act, or CELA. And that has also passed out of committee. This is not a cap-and-trade bill. It has a renewable energy standard of 50% renewable energy by 2021. And it also mandates a 30% increase in building efficiency by 2010 and a 50% increase in building efficiency by 2016. And there's also loans and funding to states for renewable energy and energy efficiency, but there's no economy-wide cap on emissions. So what this does, it encourages renewable energy, but it doesn't sort of provide the incentives to shift away from fossil fuel-fired energy. So some of the provisions in the bills that have implications for North American cooperation and trade. First, and probably foremost, is the competitiveness provisions that are in the Waxman-Markey bill, the Kerry-Boxer bill, and reportedly they're going to have identical provisions in the KGL bill. And there are two sort of prongs to the way that these bills deal with competitiveness. One is the rebate program for trade-intensive, energy-intensive industries. It's supposed to begin in 2012, which is when the cap-and-trade program is supposed to start. And it consists of allowances that are issued to compensate for 100% of industry average costs, which means that the more carbon-intensive firms receive fewer allowances than are necessary to compensate for their costs under the bill, and the less energy-intensive, so cleaner firms, are receiving more allowances than are necessary to compensate under the bill, so they're actually being overcompensated for that. These rebates are being given on a product output basis, so they're basically intended to preserve incentives for the industry on average to produce just as much as it has been producing, simply to make their industries more energy efficient. It's not clear, they probably will constitute subsidies under international trading rules, and it's not clear whether they're going to be challenged or what the legal status of those is, or how the incentives are going to play out. But that's one prong of the way that the bill deals with competitiveness. The other prong, and this is by far the most controversial prong, is the International Reserve Allowance Program. And that's going to begin in 2020, depending on international efforts to reduce greenhouse gas emissions. And that requires importers to purchase allowances at the border to compensate for the price differential between producing in the U.S., which has this cap-and-trade legislation, and producing in countries that might have more lax regulation or none at all. And it applies to imports from countries that have not been deemed to have enacted comparable climate change legislation, excepting least developed countries and sort of de minimis emitters, or countries that don't emit very much greenhouse gas at all. So basically it constitutes a de facto carbon tariff. And this is definitely the more controversial of the two prongs in terms of the international trading system. It's not a purely protectionist bill in the sense that the bill, as it is written, is very clear that that you can't charge more to importers than the cost differential between producing in that country and producing here. So it doesn't impose a burden on imports that is not also imposed in the U.S. But there are still a lot of aspects of this provision that are problematic, and it has produced a lot of anger in countries like China and India that rail against it as a protectionist measure, and it could provoke tit-for-tat retaliation. And in terms of that retaliation, it's important to remember that the U.S. has much less stringent policies than Japan or the EU, and President Sarkozy of France has been pushing for a EU carbon tariff as well that we would probably be vulnerable towards. And also we have higher per capita emissions than pretty much anyone that we trade with, including China and India. And so the jury is out in terms of WTO compliance. As I said, there are some aspects of this provision that are problematic in terms of WTO compliance. It doesn't, the way comparability is judged, it doesn't allow for any sort of differentiated responsibilities based on levels of development. It requires countries to have committed to cap-and-trade legislation or some sort of carbon limit that is as stringent as that of the U.S. So this has definitely produced a lot of anger in developing countries in particular. In terms of its implications for Canada, it's not that onerous, in fact, because most Canadian manufacturing industries are less carbon intensive than U.S. manufacturing industries by virtue of Canadian electricity largely coming from hydropower. And that's one of the sort of criteria for comparability that a country can sort of get out of having to be part of this program if their industries are less carbon intensive than those of the U.S. Another sort of implication for Canada, there are standards in the Waxman-Markey and the Kerry-Boxer bill for allowance trading internationally. And Canada-U.S. allowance trade would produce substantial gains for a lot of Canadian industries, particularly energy-intensive industries. Models show that it would cut the Canadian allowance price in half to be able to trade with the U.S., just because the U.S. is such a bigger market and is likely to be able to reduce emissions at a lower cost. So it would be to the benefit of certain Canadian industries to be able to trade with the U.S. But in the Waxman-Markey and Kerry-Boxer bills, in order to be able to trade allowances with the U.S., a country has to have a national or international carbon trading regime that imposes a mandatory absolute cap on emissions. Whereas regulation that's been proposed in Canada so far has an intensity-based cap and trade system. So instead of capping like the absolute level of emissions, it caps the emissions per unit of GDP. So that would not qualify to trade allowances with the U.S. So if Canada wishes to trade allowances with the U.S. under this legislation, it would have to adopt an absolute cap on emissions. Also, renewable energy. Canada has long advocated for its hydropower to be considered a renewable source of electricity under renewable portfolio standards introduced at the federal and state levels. And in the Waxman-Markey and Kerry-Boxer bills, it does not specifically disallow Canadian hydropower from counting towards the standard. The Waxman-Markey, the Kerry-Boxer, and also the Bingham and the Sella bills set conditions for the environmental quality of this hydropower, and also the Sella bill requires the hydropower to be incremental. So there are a number of conditions attached to the use of hydropower. A lot of those conditions are supposed to be certified by the Federal Energy Regulatory Commission in the U.S., which doesn't have jurisdiction over Canada. So it's really unclear as to how or whether Canadian hydropower can be certified in order to count towards the renewable portfolio standard in the U.S. And to be sure, hydropower does subtract from the baseline against which the standard is measured. So say you're a utility in the U.S., you have to produce 20% of your, or rather procure 20% of your electricity from renewable sources. 20% of what? That that sort of baseline, hydropower subtracts from the amount of electricity against which that 20% is judged. So in that way, hydroelectricity from Canada can contribute towards compliance with the standard, but if it's not able to be certified as environmentally friendly, then it is at a disadvantage to the U.S. in terms of compliance. Just to note that even if none of these bills are passed in the U.S., the EPA currently is obligated to regulate firms in the U.S. And there are a number of resolutions pending that will either erase this obligation for the EPA or move it back several years, but it's still on the table. And finally, just to segue into state and regional cap and trade programs, the last issue that I'd like to highlight for the federal legislation is that there are in place now, there's the Regional Greenhouse Gas Initiative in the Northeast, and there's the Western Climate Initiative in the Northwest. These are significant regional carbon trading programs. The Pew Center just came out with a study that these carbon trading programs, even by a conservative estimate, would contribute to 40% of our commitment in Copenhagen and 24% of Canada's Copenhagen commitment. So these are big, big trading systems. And Canadian provinces are part of the WCI. But there's a lot of uncertainty surrounding their future because of preemption provisions in the Waxman-Markey, Kerry-Bosser, and probably KGL bills. So under current cap-and-trade legislation, these state cap-and-trade programs will be preempted. And these regional programs, they are regional trading programs, but the individual cap-and-trade programs are administered on a state-by-state basis. So if the state programs are preempted, Canadian provinces can still have their cap-and-trade programs. They just won't now be allowed to trade allowances with the individual states. So while these Canadian cap-and-trade programs won't have to be disbanded necessarily, it does introduce uncertainty of the market. It's not clear how the disbanding of the regional program would affect the carbon markets in those provinces. So segueing to state renewable portfolio standards. As I mentioned, if federal legislation is not enacted, these state programs are going to gain a lot of importance. And to date, 30 states have enacted a patchwork of different renewable portfolio standards. They have different targets, different timelines, different definitions of renewable energy. Also, some Canadian provinces, Ontario, New Brunswick, and Nova Scotia, have also enacted these provisions. And they're not as prevalent in Canada because Canada derives so much of its electricity already from hydropower, but they're still there. There are a couple of issues with these renewable portfolio standards. One is that there are sort of barriers to trade of renewable electricity credits amongst the states. There are several different uncoordinated tracking systems for these renewable credits, and that's sort of a de facto barrier to renewable credit trade. And also the fact that different states have different definitions of renewable electricity is also a de facto barrier. So there are gains from trying to coordinate all these definitions, but that's going to be very, very contentious. In particular, large hydro is excluded from a lot of state definitions of renewable energy, and there are different reasons for this. One is the environmental friendliness issue with large dams. Another is that the state renewable portfolio standards are aiming to create new renewable generation. And you could definitely envision a scenario where if a U.S. border state adopts a renewable portfolio standard that includes large hydro, you just have a swapping. So the U.S. state would import enough renewable Canadian electricity to meet the standard, but there's nothing stopping the Canadian province from just re-importing back the fossil fuel-fired electricity that the U.S. state used to procure. So you'd have like a swapping of electricity, but you wouldn't have any new renewable electricity being generated. So that's also a concern. In terms of coordinating renewable electricity definitions, there's also the fact that a lot of states have prioritized certain forms of renewable electricity. For example, solar is given priority in a lot of state standards. Some states have prioritized certain types of renewable electricity that favor certain industries in their state. One of the more egregious examples of this is North Carolina, which requires some of its renewable electricity to come from swine and poultry waste. There's no clear environmental justification for this, but North Carolina is a big livestock state. So that would have to be scrapped if there were going to be a coordinated definition of renewable electricity. But it would increase efficiency of these standards to have that. Also, the state low-carbon fuel standards is kind of an elephant in the room when it comes to U.S.-Canada relations on climate change. It's developed by California and currently is being promulgated by California. It requires fuel distributors to reduce the carbon intensity of its fuels by 10% between 2010 and 2020, and because oil sands production generates a significant amount of greenhouse gases that conventional oil doesn't produce, it does sort of create a disadvantage for Canadian oil sands under the standard. If California is the only state to promulgate this, it's really not a big deal for the oil sands industry. California imports a negligible amount of oil sands oil. It's really not that much. But other states are considering adopting it, and one of the regions that has the Midwest Accord, which is a group of several Midwestern states that are trying to create sort of a framework for dealing with climate change. in committees, they've talked about potentially having a low-carbon fuel standard. And the Midwest is one of the markets that it gets about 75% of Canadian oil sands oil is transported to the U.S. Midwest. So if the Midwest were to adopt a standard, that would be a big deal for the oil sands industry. And oil sands is expanding into different areas, to the Gulf Coast and Asia, so there are other markets available, but it would still be a big blow to have their Midwest market reduced. And one of the points that Canada has brought up with regard to the standard is that the way California regulates, it regulates based on two sort of categories of oil. One is there's a basket of fuels. It comprises several different fuels that are comprise more than 2% of California's oil market. And that basket is combined, and there's one single sort of carbon intensity value that comes from that. And any fuel that's part of that basket gets that value. And if a fuel isn't part of that basket, then it's regulated based on its own carbon intensity. So in that way, oil sands oil is treated a little differently from, say, California heavy crude, which is in the basket. So that's a point that Canada has brought up with regard to international trading rules. So some of our recommendations for resolving some of these issues. First of all, the Commission for Environmental Cooperation is a body that was created as part of NAFTA, and it deals with environmental issues amongst the three countries, but it hasn't done too much with climate change yet. So it really should serve as sort of an institution for research on how we can coordinate climate change legislation, and also a database on both what climate change regulation is out there, and also sort of a clearinghouse for inventories of greenhouse gas emissions. Next, to the extent it's possible, perhaps renewable electricity definitions could be standardized. As I mentioned before, there are a lot of problems with this, particularly with how large hydro is going to be treated. But there does need to be a dialogue so that we can come to how should large hydro be used without sort of promoting the swapping that I talked about earlier, and promoting environmental quality. If we can import hydro to meet the federal renewable electricity standard, how is that going to be certified? Those questions need to be addressed. Then a NAFTA, it would be a good idea to adopt a NAFTA peace clause with regard to the border allowance provision in U.S. legislation. And in fact, the bills on the table do push it back to 2020. In order to develop a framework for how we're going to deal with all of these carbon tariffs, that needs to be developed internationally. There needs to be clear rules for what is legal internationally and what is not, in order to forestall sort of a wave of litigation over these provisions. So that, in order to negotiate that, that requires some time and some breathing room. So it's a good idea to have these international border allowance provisions sort of pushed forward to a later date to allow time for these frameworks to develop. Next, there should be a safe harbor to shield climate change regulations from claims under Chapter 11. And so far, Chapter 11 has been interpreted pretty narrowly in dispute settlement, and dispute settlement has sort of made it clear that there is a lot of room for states and countries to develop environmental regulation without it sort of be constituting expropriation under Chapter 11. But climate change legislation is going to have much broader economic implications than environmental legislation to date. So there needs to be some clarification under Chapter 11 as to what is legal, what is not with regard to climate change and the environment more generally, in order to forestall sort of a wave of litigation under Chapter 11 going forward. And that concludes my presentation.
Professor Irish.
Good morning, everyone. It's a pleasure to be here, but I have to say that along with many other people here, we really miss Henry. So, I'm glad to see the bell is there, and I'm going to watch and make sure that, I stop before I get the bell. I'm going to be talking about regulatory convergence, and I'm going to talk about the legal framework. Unfortunately, what I'm arguing is that there are some issues in the legal framework, I think, that set up perhaps some problems as regulatory convergence is pursued. I'm suggesting that regulatory convergence is hard to do when we don't have convergence of governments, but we'll see how things move along. First, I'm going to talk about some issues of the vocabulary that I will be mentioning. Then I will speak about what I believe to be a mutual recognition agreement that's already present in NAFTA, and then I'm going to talk about these potential legal problems flowing from MFM rights in the WTO. So first, concerning vocabulary, obviously when we're talking about standards that apply to goods, national treatment is the easiest thing to apply. There's nothing to coordinate there between governments. For national treatment, imported goods simply meet the standards in the country of import, in the host country, and they simply need to receive treatment at least as favorable as that of domestically produced goods. That's very easy. Harmonization of standards is difficult to do. You have to negotiate. It takes a lot to come to a uniform standard, so that's difficult. The one in the middle, the recognition standard, recognition of equivalence, that also requires ongoing coordination and negotiation. With recognition of equivalence, the goods, the imported goods, do not have to meet the standards in the country of import, the host country, because their standards in the country of production or export are recognized as equivalent to those standards. So the home country standards are recognized as equivalent, and therefore the imports can circulate freely in the country of import. So I'm going to be talking about what I see as a framework of an existing mutual recognition agreement in NAFTA, and I'll talk about the SPS chapter, the TBT chapter, and then I will move to similar provisions in the WTO. SPS, sanitary and phytosanitary provisions obviously apply to standards having to do with the life and health of plants and animals, including humans. And TBT, technical barriers to trade, applies to all other standards related to measures concerning goods. Now, in NAFTA, we already have significant encouragement for harmonization. First, in the SPS chapter, each party should consider the relevant SPS measures of the other parties when it's developing its own SPS standards. And in the TBT chapter, the parties shall make compatible their standards-related measures to the greatest extent practicable. It's qualified, but the word there is shall. And in the definition section, Article 9.15, make compatible includes bringing goods or bringing standards-related measures to a level such that they are either identical which would be harmonization, equivalent or have the effect of permitting the goods to be used in place of one another or fulfill the same purpose. So make compatible includes harmonization and also some recognition of equivalence. So within NAFTA, we already have this obligation towards harmonization. We have a significant obligation concerning equivalence in SPS. Each importing party shall treat the sanitary or phytosanitary measures of the other party as equivalent if the exporting party demonstrates that the measure achieves the importing party's appropriate level of protection, but that's a shall in the provision. The importing party can refuse to recognize equivalence on a scientific basis, and if it does so on request, it shall provide written reasons. So there is already an equivalence provision in NAFTA concerning SPS. Same thing in the NAFTA chapter concerning technical barriers to trade. Shall treat a technical regulation. Now, a technical regulation is a standard that's obligatory, it's mandatory. If the particular measure is not of mandatory application, then we just call it a standard, but a technical regulation is something that applies to goods in a mandatory way. And in the TBT chapter, each importing party shall treat a technical regulation of the exporting party as equivalent if the exporting party, once again, demonstrates that that technical regulation adequately fulfills the importing party's legitimate objectives. The importing party, the importing country, can refuse to recognize equivalence, but once again, if it does so on request, it must provide written reasons. So there is already in NAFTA, I think, the framework for an existing MRA. I'm moving now to the comparable position in the World Trade Organization, in the SPS agreement, and the TBT agreement at the WTO. And on the screen I have the provision concerning the SPS agreement at the WTO. And you'll see it's actually fairly comparable to the NAFTA provision. In the SPS agreement, a member shall accept the SPS measures of another member as equivalent if the exporting member demonstrates that the measure achieves the importing member's appropriate level of sanitary and phytosanitary protection. The main difference here between this and NAFTA is that you'll see we don't have the same procedural rights. There's nothing saying that if the importing member refuses to recognize, then on request it must give written reasons. But nevertheless, the active word in Article 4.1 is shall. This is an obligation. There is as well, within the SPS agreement, a tendency towards the encouragement of MRAs. Members shall, on request, enter into consultations with the aim of achieving bilateral and multilateral agreements to recognize specified SPS measures. This may be very specific rather than an overall MRA. The rights concerning the TBT agreement at the WTO are significantly weaker. Concerning TBT, this is all other standards. Concerning TBT, members simply need to give positive consideration to accepting a standard as equivalent, provided they're satisfied that it fulfills the objectives of their regulations. So this is weaker than the NAFTA obligation to recognize. Article 10.7 contains, however, encouragement toward the development of mutual recognition agreements. Members are encouraged to enter upon request into consultations for the development of such agreements. Now, I'm moving to the legal question that I'm going to raise. It is a bit of a challenge, and my question has to do with the standard obligation in trade law of MFN treatment. GATT Article 1 says that any advantage, favor, privilege, or immunity granted to a product originating in one country shall be accorded immediately and unconditionally to the like product originating in any of the other WTO member countries. Well, now, what does this mean concerning an MRA? The right for an import to circulate freely in the country of import without meeting the domestic standards there surely has to be within the phrase here of an advantage, favor, privilege, or immunity. So surely there has to be something here that comes from having an MFN right. And the question really is, what exactly has to be accorded immediately or unconditionally to the products of other WTO members? What exactly is required in this MFN right? Joel Trachtman, writing in the Journal of International Economic Law in 2003, said that if a country failed to recognize a home country regulation that meets the goals of the importing country, then that would be de facto discrimination. He is assuming, I think, a standard here, and the context of the article, I think, assumed the standard of the Cassis de Dijon decision in the European Community concerning a provision in the Treaty of Rome on measures equivalent to quantitative restrictions. Under the Cassis de Dijon principle, and I'm sure others here will have more specific interpretations of the principle, but I'm just going to say that any product lawfully produced or marketed in one member of the community must have free access to other member countries of the community unless it would harm legitimate interests in the importing state, such as public health or consumer protection. Now, if that's the overriding principle, then MFN is a significant obligation. The idea that MFN would carry that much weight means that, in fact, it would be difficult to negotiate a closed mutual recognition agreement. In fact, this means that any mutual recognition agreement should be seen as probably open to other countries, provided their goods would not harm legitimate interests in the importing country. And Laurent Bartels argues that actually in the Journal of International Economic Law in an article published in 2005. So there is a significant scholarly discussion here to say that the MFN requirement has a fair bit of weight. Now, I'm not going to be able to here provide a resume of all of the discussion, but I'm listing here a few of the possibilities about what the MFN obligation might be. And the first one I've already talked about, the Cassis de Dijon standard, goods being able to circulate lawfully in the importing country unless they harm legitimate interests there. Would we say instead that that's not the standard, but we might say that goods would be able to benefit from the MFN treatment if there is a demonstration that the regulation in the exporting country meets the particular goals of the importing country. Now this is, I believe, the NAFTA standard that we just saw in the SPS and TBT provisions of NAFTA. Maybe that's one way, another way of looking at the MFN standard. We might say instead that the MFN obligation would come into play if the regulation of the exporting country is substantially the same as the regulation of the importing country. Here, I'm not just looking at whether something actually meets the goal, but whether the regulation itself is substantially the same. In other words, it's not just is the lumber strong, but is the lumber thick enough? Does the lumber have too many knots in it, etc.? In other words, using the same regulating factor. Looking at things, for example, not just in terms of performance, but perhaps the design or descriptive characteristics of the standard. That's a possibility. If we use that approach, there is actually already GATT jurisprudence to say that an MFN obligation in fact could come into play there. In 1981, Canada won a GATT panel decision against the European Economic Community because of Article 1. The community was failing to recognize standards for beef, and the argument by Canada had to do with the fact that the community was accepting two U.S. standards, prime and choice, as indicating quality of the beef because cattle had been fed for 100 days on high-energy food, etc. And the community had not accepted Canadian standards that Canada said provided the same kind of assurance. In fact, at the time, the U.S. was accepting those Canadian standards as meeting the requirements for U.S. prime or U.S. choice goods. So the United States was accepting those standards, but the European community was not. The standards were substantially the same, and Canada won the GATT dispute. It was held by the panel that the community was in fact breaching Canada's MFM rights. So we have at least one GATT panel decision confirming the operation of MFN on that interpretation for recognition of standards. Now, there's another question about what would be involved in according the same right immediately and unconditionally. If there is a regulation presented for mutual recognition, does the exporting country have to offer mutual recognition itself? If the exporting country is saying that its standards should be accepted under MFM rights, could the importing country say, well, maybe, but you have to recognize our standards as well? In other words, could the importing country impose an obligation of mutual recognition back? Laurent Bartels, in the article I mentioned earlier, says that the importing country cannot demand that because MFN treatment is to be accorded unconditionally. I have some concerns about that interpretation because I think that would turn the MFN right into a higher right than the original right. I don't see why the multilateralized right should be stronger than the original right in an MRA agreement. So there is a discussion then about whether MRAs can be closed or whether they must be opened in some way because of MFN rights. Is there an MFN obligation to recognize? The discussion that I was just talking about, I think, indicates that there is some obligation, and it could be a fairly strong obligation. I'm arguing that it should actually be seen as a somewhat softer obligation, an obligation to consult with a burden of proof that would match the original right. And I think that if we have a softer interpretation, we wind up with something that actually fits the assumptions in the SPS agreement and the TBT agreement, that in fact MRAs are possible. Those two agreements seem to be talking about the possibility of entering into an MRA that would be bilateral, and it seems to me that it would make sense to interpret the MFN right in a fairly soft manner to make it fit with those agreements. But it is possible to say that there are MFN rights in addition to whatever rights are in the SPS agreement at the WTO and the TBT agreement at the WTO. So now I'm asking whether members of the WTO would be able to say that they are entitled to the benefit of NAFTA rights. If I have just said that some of the NAFTA rights are stronger than the WTO right, could another member of the WTO use MFN rights to say, okay, we're entitled to that stronger NAFTA right? I think that it's not likely to matter that much concerning SPS rights because those rights are similar anyway. However, we know that in NAFTA there is an obligation for written reasons if those are requested when the importing country refuses. There is a significant difference, however, as I said, between the WTO TBT right and the much stronger NAFTA TBT right. So possibly some other member of the WTO could demand TBT rights for recognition of its technical regulations using an MFN obligation. And I hope I haven't lost too many people. I realize it's a little early in the morning for a somewhat technical argument. That's why I was putting up provisions of the articles themselves. If we say that in fact there are WTO rights that go beyond the ones in the SPS agreement and the TBT agreement, then exactly the same arguments would apply concerning a separate Canada-U.S. MRA. It would be precisely the same thing, a WTO member being able to demand an open MRA, even if Canada and the United States thought that they had negotiated a closed one. And then I've raised the question of whether there might be similar arguments within NAFTA. Canada and the U.S., let's say, negotiate a separate MRA. What about Mexico? Would Mexico be able to ask for treatment within that MRA? Mexico, at the very least, would have whatever is available to all members of the WTO. I just want to mention that within NAFTA itself, there is as well a full MFN clause in the TBT agreement. It's in the TBT agreement, it's Article 904, sub 3, sub B. So, in fact, Mexico would have those rights as well. So, overall, I'm saying that regulatory convergence is demanding. It's hard to negotiate. It's hard to coordinate standards. It's hard to organize mutual recognition and update things every time a regulation changes. I'm saying that NAFTA already has significant rights for recognition of equivalence. So if we're thinking of negotiating MRAs beyond that, we would need to discuss why the NAFTA provisions are not significant, are not sufficient. And overall, I'm suggesting that the possibility of MFN rights needs to be kept in mind. So I thank you for your attention.
Now we have time for questions from the audience. Yes.
Regarding the energy, what is there a bill, or are there some really good provisions that would allow Canada and the U.S. to have a synchronized, harmonized standard? Because we're going to need that. I mean, Mexico will need to be harder, but the U.S. and Canada are going to have a similar regime that moves the ball forward. Is there anything out there right now that you think does that, or is that to be decided?
There's nothing, to my knowledge, in any of the bills on the table that deals with U.S.-Canada coordination. Like, it's simply not addressed. So I guess my answer would then be to be determined.
And I would add, one interesting thing was that before, and I think I mentioned it last night, before President Obama made his trip to Ottawa, which was a year ago February, a very good trip, the environmental minister, Jim Prentice of Canada, had a pretty good meeting, and he talked about coordination with Carol Brown. I mean, so they've been talking about it, but I think probably Canada, and Jim Peterson know this, are probably waiting to see what the U.S. is going to do, and of course the U.S. has really slowed the whole battle down. And probably slowed down until after the election, although there may be some energy legislation. It may not be the kind that you were talking about.
Yeah, that's absolutely true. Canada has declared recently, they said it in their Copenhagen pledge, actually quite explicitly, that they're going to follow what the U.S. does on climate very closely. Their target that they submitted to Copenhagen was exactly identical to the U.S. target. Not only that, they had a clause that said that this target is subject to whatever the U.S. does on climate. So it's very true that Canada is sort of adopting a wait-and-see approach. They want the U.S. to pass its legislation before they're going to pass anything themselves. And this is with, there are models that show that because Canada is a relatively small economy compared to the U.S. and they're so heavily integrated, it's, I guess, understandable that they would want to do this in order to minimize sort of the impact on some of their more carbon-intensive industries. I think that's a concern for them. So, yeah, it's been very wait and see in Canada, and there also has been a lot of talk about coordinating some of these initiatives, both at the high level. There's been talk. My boss Jeff Shaw sits on the Joint Public Advisory Committee as part of NAFTA. And there's been talk within that body as well of coordinating some of these initiatives, but nothing embodied in the legislation that really allows for this.
I'm Dick Cunningham. I'm Dick Cunningham from Washington. I'm a trade lawyer. Let me address the question of this big thing. And let me tell you what bothers me most about all of this, and what seems to be to make it almost impossible to see how this is going to be resolved internationally. You talked about the international allowances, the import purchasers' allowances, as a competitiveness position. It's very different from the type of competitiveness measure that we think of traditionally in trade, where you impose a burden on a domestic industry, and then to level the playing field, you impose the same burden on a foreign company. That would mean, let's say, the U.S. company has a carbon footprint of 10 and has a burden imposed on it of 10, and you impose the same burden on the foreign company. As I understand it, that's not what we're doing at all. We're imposing a burden measured by the foreign company's carbon footprint, which in the case of China might be, say, 50. And I've seen studies saying that that would impose huge burdens on Chinese imports. And I won't get us into the mind-numbing complexities of Article 20 justifications and the exceptions, but it just seems to me that not only will the WTO recoil from imposing on, for one country imposing on another country a burden disproportionate to that imposes it on its own domestic industries. But also this would lead to, in the words of that great trade lawyer, Saddam Hussein, the mother of all trade wars.
I mean, the details of how this program is going to be administered are not, they're not in the legislation. They're to be determined pretty far in the future. So exactly how this measure is going to be imposed, whether it's going to be done based on U.S. carbon intensity, foreign carbon intensity, whether there's going to be, according to WTO jurisprudence, it seems that in order for the standard to be WTO legal, like in the shrimp turtle case, they said that there needs to be some form of appeal, that foreign firms need to be able to appeal, their treatment under the border allowance provision. If, say, their firm produces their widgets like in a quote-unquote green manner, they need to be able to appeal their treatment. So there are definitely WTO issues with the border allowance provision, and it would actually make things a lot easier if we had a carbon tax. Then we could just do a BTA on foreign products, but that's not the approach we're taking. So the International Reserve Allowance Program, it's trying, like, the way the legislation is written, it's trying to be a de facto BTA, but I think it would be treated somewhat differently under WTO rules.
Is that really what we're trying to do, or are we in fact trying to get, say, put pressure on China to reduce, to adopt a climate change regime that would achieve similar reductions to ours? Because that seems to me that where this is headed, and that seems to be anathema to the trading system.
That is, in fact, one of the stated goals of the legislation, is to act as a stick against China. I don't think it's going to be particularly effective at that. The industries that this border allowance provision applies to, it's a pretty narrow set of industries. These are not industries in which exports to the United States for China and India comprise a large portion of overall production. So it's by all of our estimates at the Peterson Institute, it's not going to be a very effective stick, but that's one of the goals of the legislation. The way it's written to apply in practice, like I said, it's only supposed to impose costs that, if that firm were producing in the U.S., they would have to undergo. And actually, for the first few years of the border allowance program, the rebates are scheduled to start phasing out in 2025. They'll be phased out by 2035. So at the beginning, from 2020 until, I guess, 2027, 2028 or so, the International Reserve Allowance, they might not even end up having to buy any allowances at the border, because 100% of industry average compliance costs are supposed to be compensated for anyway within the United States. And that has to be taken into account under the U.S. legislation currently. So, I mean, my sense is that the legislation as written is it's narrow, and it's narrowly focused, and it's not going to start having large effects until much later into the future. But I guess that, again, the devil is in the details as to how this is going to be administrated, and there's a lot that is left up to the EPA administrator and the executive branch as to how to apply this law. So
I had a question, Kai Carmody from the University of Western Ontario. First of all, on this issue of using the CEC as a clearinghouse to adopt sort of uniform definitions or standardized definitions for some of these issues that are coming up in the environmental sphere, does the CEC have the power to do that? Is it actually given that capacity in its treaty? That's one question I had. Yeah, so please go ahead.
the CEC really doesn't have a whole lot of power at all. I think the way that we suggested using the CEC is that what it serves as is, one, a forum to talk about these issues, and it should be used as such. Two, it's a research arm, almost, of NAFTA with regard to the environment. They publish a number of reports every year, and they could do more with sort of highlighting the regulation issues, highlighting what's on the table in the U.S. and Canada, and highlighting where the sources of greenhouse gases are coming from in each of the three countries. Like this is information that the CEC is very much poised to be disseminating to the public, and they could be adopting a much broader role in doing so. In terms of, like, I guess, requiring these jurisdictions to harmonize their environmental provisions, it really doesn't have any sort of power to enforce, to mandate that, if you will, but it could serve as a forum if countries, by themselves wish to do so.
Okay, and then I had a second question for Maureen. Maureen, do you think that the issue of MFM treatment is something that complicates the conclusion of MRAs, and therefore, to some extent, explains why we haven't had more advances in this area? Countries haven't been willing to rush into MRAs because they're worried about this claim that some third country may say, we need the same treatment because we're part of the same trading bloc.
I suppose the question is whether people are actually worried about MFM rights at all. I don't know that a great deal of the discussion about regulatory convergence has actually highlighted this issue, and it's one that concerns me. So I'm not sure that, say, a slow development of MRAs could in fact be attributed to concerns about this. If it turns out that, in fact, there are MFN demands, then certainly they could be fairly onerous. Imagine having to give written reasons for every refusal to recognize. It could be onerous, but I have to say that I don't think this is an issue that has been much discussed, except in the Journal of International Economic Law, which of course we all read regularly. But outside a fairly specialized field, I'm not sure that's it. I think mutual recognition, in fact, itself is difficult to organize, because you do have to have some provision for continuing updating. Standards change, governments regulate. It's hard to coordinate.
David Fong here. I would like to, first, I'm not a lawyer, and I haven't heard the presentation. I don't really want to be one. I don't know how you're going to deal with the issues, because we as business people, we run way ahead of what these regulations are doing. You take the iPad that has been distributed. Inside, there are probably 20 to 40 components in that. So what are the regulations being followed for each one of those components? And how do you define, is that really a product of China? Is that made in China? But it's only the labor component, $12 out of the $500 is from China. So how do we define the product? What are the regimes that one would use to define that product?
Certainly, I think there's a great deal of standardization that simply has developed through market forces. Some of it would be through recognized international standardizing organizations, and some of it is simply through the operation of market forces. And if that's the case, is there really a need for governmental MRAs, I suppose, is the issue.
Thank you. Maybe I can just have the other question on our legislators, our politicians, are also really falling way behind. And let me give you an example that you mentioned about the issue of hydropower at the border states and the coal-fired power plants on the U.S. side. And the legislation trying to prevent that kind of bilateral trade. And that is the most harm we can do to the environment. Because if our legislators understand that if Canada does not import those coal-fired power plants excessive power during the night, those five power plants will have to shut down. Cause enormous damage to those power plants. And if the Canadian hydropower would not stop at night, and they would not be able to export as much during the day, then the United States would have to build a lot more coal-fired power plants to meet its peak power demand during the day. So we should really encourage that kind of transfer rather than try to discourage them. And so by putting in regulations, thinking we are trying to be green, we're actually going to cause a lot more carbon emission in the process.
Well, let me clarify. It's not that the border states are disbarring hydropower from being imported at all. Or even trying to limit the imports of hydropower from Canada. That's not what they're trying to do. But in the renewable portfolio legislation itself, which that is a mandate that a state has to produce a certain percentage of their electricity that they procure from from renewable energy. In that particular legislation, there are certain types of electricity will count as being renewable, and each state sort of specifies what those types of electricity are. And so it's not, like, if the status quo is that a state is importing a large amount of hydropower from Canada, the renewable portfolio legislation is not intended to stop that at all. What it's intended to do is that, in addition to sort of the status quo of that state's generation, it wants to create new renewable generation. So if hydropower, if it's economical for the state to be importing a lot of hydropower from Canada, it's not intended to stop that at all. What it's intended to do is create new renewable generation. So different states treat that differently, and some count large Canadian hydropower as renewable electricity. Some wish to keep the definition of renewable electricity limited to certain kinds of electricity, such as solar and wind. These things that states wish to scale up in the future in order to provide additional sources of generation that are not present under the status quo right now, in order to combat climate change. So I guess that's a long-winded way of saying that it's not a barrier to hydro being imported to the United States at the status quo level. It might not necessarily encourage additional imports, but it's really not the same as saying that that the state is just like disallowing hydropower from being imported. I thought you brought up a really good point with regard to the products being comprised of like many different parts before they're shipped off to their final destination. With regard to emissions, and just getting back to your question about how this is going to be applied and whether it's going to be applied at the foreign emissions level, the U.S. emissions level. Calculating the emissions that go into a particular product that's being imported, that's been constructed in like 12 different countries, would be an administrative nightmare. Which makes me as not an insider to this process at all, and just my guess is that they would probably want to like calculate the emissions intensity of a certain product at like the U.S. emissions intensity, just to prevent that sort of like administrative nightmare where you have this product, it's been assembled in like 15 different countries, and you're trying to estimate like how much emissions went into it at every step of the way. I mean, it seems like it makes more sense to regulate at the domestic emissions intensity.
One more question, then we'll have to take our break. Yes, right here. Somebody get a microphone to him there.
Thank you. Bernard Hibbets, a Canadian teaching at the University of Pittsburgh Law School. You said something very interesting, Maureen, at the beginning of your presentation, and that was that regulatory convergence is hard to accomplish without convergence of governments. And I'm pretty sure I know what you mean, but I'd love to have you elaborate on that, because of course there are all kinds of pregnant possibilities in that statement. Thank you.
It seems to me that it's easier to have a principle such as the Cassis de Dijon one in the European community, when there's an overall governmental structure at the community level to establish agreed community regulations, and there's systems there for decision making. As between sovereign independent countries, we simply don't have that. And it seems to me that it's difficult to talk about mutual recognition agreements or regulatory convergence unless you have some sort of centralizing institution along that line. And if there is a centralizing institution, obviously you look at balance of power within the institution, how things actually operate, etc. So governments regulate in an ongoing way. That's what they're supposed to do. If we assume that there is going to be convergence, then Do we need other levels to coordinate? I'm not saying that it's impossible for governments to cooperate, but if we're expecting that things will be very, very coordinated, as within the European Union, then we need a structure that is very, very present. And I don't think that sovereign independent nations really expect that, or do their publics. So it just seems to me that regulatory convergence is in some ways challenging.
Let's thank our panelists and go on for our break.